We'll call to order this meeting of the Tennessee Advisory Council on Workers' Compensation. I'm David Lillard, Tennessee State Treasurer and Chairman of the Council. I welcome you here to this meeting today, Monday, February 22, 2016, at approximately 11 a.m. Central Time in the Legislative Plaza, the state capitol in Nashville, Tennessee. I'm going to ask Ms. Schroeder to call the roll.
Chairman Lillard.
Here.
Carrie Dove. Here. Bruce Fox. Here. John Garrett. Thank you. Bob Pitts. Here. Gary Selvey. Here. Paul Schaefer. Here. John Burleson. Jason Denton. Here. Sandy Fletchall. Keith Graves. Abby Hudgens. John Harris. Lynn Lawyer. Jerry Mayo. Sam Murrell. Dr. Murrell? Gotcha. Greg Ramos. Here. Mike Shinnick. Here. Representative Eldridge. You have a quorum physical.
All right. We have a quorum, and we also have members participating by phone. The next item is item number 2 on the agenda, approval of the minutes of the February 18, 2016 meeting, which were distributed to you previously. Are there any comments, questions, or amendments to the minutes as proposed? Seeing none, Chair would entertain a motion with respect to the amendments. So moved. We have a motion. Do we have a second? All right, we have a motion and second for approval. The minutes February 18, 2016. Just do this by voice vote of the voting members. All those voting members in favor signify by saying aye. 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 Those opposed, no. The ayes have it, and the minutes are approved. All right, we'll go to item number 3, which is new business. First legislation to review is House Bill 1720, Senate Bill 1758 by Representative White and Senator Green. Let's see, is anyone here to present on this bill? Okay, I know Dr. Murrell wants to comment on it. All right, Dr. Murrell, do you have comments on it? I believe you're on the phone today. Go down there and tell them to hold one of the mics up to that speaker.
Any penalties for this. Not only does it concern me because the provider isn't provided payment as due under the fee schedule, but also it takes what was from the previous fiscal note a fiscally neutral bill and removes essentially the pay for the bill, namely the penalty.
All right, thank you, Dr. Murrell, for those comments. Are there any other comments or discussion points on this bill? All right. Does anyone have a motion or other discussion points on this bill as SB 1758, House Bill 1720? Mr. Pitts, you're recognized.
Mr. Chairman, I just make an inquiry. We do have the purported agreed upon amendment before us. Okay.
Yes, that amendment has been filed, and that's the amendment number.
Let's read into the record the amendment number. Okay, we got the legislative drafting code number.
The amendment number is 12573.
Okay. All right. Having the bill and the amendment before us, is there a discussion or a motion with respect to the bill and the amendment? Yes, sir.
Can I add that
Dr. Murrell's recognized.
Or can I ask the council to perhaps at least include those comments of mine, and or even to make a recommendation to that consideration be given to address those deficiencies?
Certainly, Dr. Murrell, as a member of the council, your comments will go with the record of the bill to the committee, assuming it goes there today. Okay, Mr. Fox, you're recognized
I move that council adopt the bill
And-
with the recommended
with
changes.
the amendment.
Yes,
With the amendment, okay, as the drafting code was previously read. So we have a motion to report the bill out with a positive recommendation for passage with the amendment. Is there a second? All right, we have a second by Mr. Dove. Any discussion on the motion? All right, seeing none, I'll ask Ms. Schroeder to call the roll of the voting members.
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Gary Selvey. Paul Schaefer. Unanimous.
All right, unanimous in favor, so the bill with the amendment goes out to the committee with a recommendation for passage by the advisory council. The next item is House Bill 1869, Senate Bill 1706 by Representative Farmer and Senator Gardenhire. It's the chair's understanding that this bill will be merged by an amendment with House Bill 2416, Senate Bill 2582 by Representative Lynn and Leader Norris. That bill is on the last item on your calendar under item number 3 here today. Are there persons who want to speak on this particular set of bills, these two bills as combined by an amendment? And do we have the amendment on this, Ms. Schroeder?
We do.
All right. Do you have the legislative drafting code on the amendment?
No.
All right. Do we have the amendment itself?
The amendment's in our packet under the 2416. There's no drafting code that I have as of yet. Does anybody? No.
Okay. Let's see this just a minute. Okay, the amendment itself is 2.5 pages long, or I'd have Ms. Schroeder read it, but I understand that each member has it in their possessions. Any member need a copy of the amendment or has not seen it? Okay, any discussion on the two bills as merged by this amendment? This is labeled House Consumer and Employee Affairs Subcommittee 1, Amendment 1 to HB 2416. Sponsor, Representative Lynn. Mr. Fox.
Mr. Chairman, after working, after last week's meeting and over the weekend, both sides who had issues with this bill merged the two and reached an agreement. The substantive changes is the notice provision has been reduced from 30 days to 15 days, that attorney's fees, reasonable attorney's fees may be awarded under Section B, where the employer wrongfully denies benefits. I would suggest, just as a house cleaning matter, that under B, we start with the sunset provision. I think that should be reversed. I think 1 should drop down below 2. Mm-hmm. It will make more sense that way to show then that what's above it is what is being sunsetted, not the previous portion of the bill.
Okay, so you're reversing the positioning of the provisions B1 and B2 by.
I think that would clean it up and make it
one.
more
Okay.
comprehensible
All right.
for those of us who were not present while we discussed
Right.
and or tried to articulate what our intent was. The intent is only to sunset the section of B that deals with attorney's fees, not the entire bill. And I think if we change 1 down to 2 and 2 up to 1, that'll clarify it.
Great. Okay. All right. Any questions or discussion on the bills as merged by this amendment that's been under discussion here today? Anyone in the audience wishing to speak to it? All right, Mr. Pitts, you're recognized.
Mr. Chairman, I move the amended bill.
All right, we have a motion for the bill as amended. Is there a second for that motion? Second. We have a second by Mr. Fox. Discussion on the motion. All right. Seeing none, Madam Director, Ms. Schroeder, call the roll.
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Gary Selvey. Paul Schaefer. It's unanimous.
All right, having received a unanimous vote of the voting members of the council. The bill goes out with the amendment with a recommendation for passage. All right, the next item is House Bill 2194, Senate Bill 2580 by Representative Coley and Leader Norris. And I understand that Mr. Jim Summers wishes to speak on this bill. Mr. Summers, come on up here to the microphone if you would. Just make sure the mic's turned on at the base of it there, and speak into the microphone. Identify yourself.
Testing 1 2. All right.
All right, that's good. Identify
Chair-
yourself for the record and state your affiliation. Thank you.
Mr. Chairman, I'm Jim Summers. I'm a lawyer from Memphis, Tennessee. I have a background in construction law, as well as representing companies in CGL cases, also personal injury years ago, and then I've also dealt with workers' comp. I'm here to speak on behalf of Senate Bill 2580 regarding the allocation of fault to employer. Mr. Chairman and members of the committee, I have been practicing law for 40 years. In 1992, comparative fault became the law in the state of Tennessee. And one of the most wonderful things about comparative fault was that it took away the concept of joint and several liability, where someone could sue somebody and several people would be at fault, and then they just simply picked the person who had the most money and went and got all the money from that individual, and then it was up to that individual to go back against everybody else and try and get it. So frequently you had people who had minimal fault and were forced to pay entire judgments because they were not able to collect from anybody else. The Supreme Court in the McIntyre case changed that and brought us into line with a lot of other states. And as time has evolved, those cases construing that have evolved as well. One of the first anomalies that popped up as a result of the McIntyre decision was when an employee got hurt and sued a third-party defendant. And because we were at comparative fault, the third-party defendant looks back and looks for other parties that might be responsible for the injury. And when they do that, frequently they look back at the employer and see that, oh, sorry, you didn't train him, you took a guard off, you gave him equipment that didn't work, or you basically, you showed some fault in this. And so the first case that went up was a case called Ridings versus Parson. And I remember reading that case when it came out from the Court of Appeals, and the Court of Appeals said, well, we are now a comparative fault state. We're going to allow the third-party defendant to allege fault against the employer because it's not fair to make the third-party defendant pay for fault that's not his. Supreme Court took a look at that, and they said, no, we're not going to allow it. We feel like we're stymied by the workers' compensation statute. And so we had a series of decisions after that. Pardon me. There was a Snyder decision that came out in 1996, which basically said that a third-party defendant can argue that the employer is guilty of fault, but it has to be the sole cause in fact. And just for the easiest way to put this is it's got to be 100%. It's all or none. So basically they presented an almost impossible burden of proof for a third-party defendant. Subsequently, there were two more decisions, but the one I'm here to talk about, only because the Supreme Court invited the General Assembly to make some changes in the law, was the Troop versus Fisher-Still decision. And before that, there was one other case called Carroll versus Whitney, and in that case, they simply said, we're going to allow a jury to apportion fault to a party that cannot be, to a non-party that cannot be sued either because of statute of repose, they've been too long, or because they've got statutory immunity. So we now have everything in place in which theoretically a third-party defendant could bring in and not sue an employer, but at least allege fault against the employer and to reduce the amount of fault that's applied to that third-party defendant. And why is that important? And the reason it's important is because the way the law exists right now is that a third-party defendant who is 1% at fault could be held liable for an entire judgment 100%, even though the employer may be 99% at fault. Let's just leave the employee out of it. And that's the way the law exists right now. And I can look at each and every one of you, voting and non-voting members of this committee, and I can tell you that you and your families and everybody in the state of Tennessee is at risk because of this. Let me give you just a quick example. You're driving home after the Legislative Assembly today, and somebody pulls out in front of you. And the person that pulls out in front of you is an employee. And that employee is driving a truck or a vehicle that was given to him by his employer. And maybe the brakes are not working very well. Maybe there's some maintenance issues. And maybe the employee might have been able to stop. And let's add one more fact to it. Let's assume that you're doing 5 miles over the speed limit. So technically, you're guilty of fault because you're speeding. But the employer who put that employee out on the road, it may be guilty of much greater fault because that car wasn't able to stop at that stop sign. Now let's just add to it. Say you hit him and he has a brain injury. Supposing he has medical bills of $500,000, $700,000. Supposing you have insurance of $300,000, $300,000, whatever, and let's assume that you're 10% at fault. The way the law exists right now, it doesn't make any difference whether you're 10% at fault. You're going to buy, unless you can prove that that employer was 100% at fault, which you can't prove because you're at fault, now you're going to be responsible for the entire judgment, which could be in the millions of dollars or less. It doesn't make any difference. The point is that you are now being held responsible for the fault of the employer. And that's the way the law exists right now. So in the Troop decision, the Supreme Court looked at that and said, you know, this isn't right, and here's how we fix it. But we can't fix it from our end. It's going to have to be fixed from the legislation. And here's what we're going to do. We're going to allow you to go in. We suggest you go in and you look at the third-party allocation and you do two things. The first of which is to simply say that we're going to allow somebody that gets sued by an employee to allege comparative fault against the employer, just like you can in every other tort case. But in order to make it fair, we're going to reduce, to the extent of the employer's negligence, their right to subrogate against the employee for whatever monies are received. And that's what this bill does. It simply says, one, we're going to allow all people who are sued by an employee to be able to go back and allege fault against the employer, and secondly, to keep the employee from having to be required to pay an entire subrogation lien. We're going to reduce that lien to the extent that the employer is guilty of fault. Now, what that does, obviously, is from a policy standpoint, is it makes it fair. It simply says we're all in this together, and we're not going to make somebody pay a greater amount than what they're for fault for which they're not responsible. So I'm about to lose it. I'm going to have some water. You mind? Excuse me for a second. The bill as drafted is very simple. It simply takes the existing workers' compensation statute, which is 50-6-112, and adds just two little simple phrases, one of which simply says we're going to allow an allocation of fault, and then secondly, we're going to reduce the employer's lien to the extent that the employer is found at fault. I want to suggest to the council. I read the committee minutes from 2 years ago when similar legislation was introduced, and at that time, no one stood up to defend the bill. And I want to talk to some of the issues that were raised, and I assume that some of the people will have some questions about it. But one of the first things that was alleged was that this would change the no-fault system as far as the employee is concerned. And I disagree with that. This does not have anything to do with whether or not an employer is responsible for paying a workers' comp when an employee gets injured. There's nothing about this that changes that in any form, in any fashion. So what this does say is that if an employee gets injured and sues somebody, now we're getting into a different situation. So people say, well, gosh, that's going to make it a little harder for the employer, and it's going to make it harder for the TPAs. It's going to make it harder for people to resolve cases because now the employer's got to be concerned about whether or not he's going to get to his entire lien. And I have been dealing with defendants and cases for a long time. Mr. Fox, I think I had one with you years and years and years ago. You're from Clinton, is that right? All right, sir. And I show up in mediations, and I've shown up in a lot of places, and I've tried lawsuits. And here's what I found. I found that the first time the third-party defendant gets sued, the first person they look at is the employee. Because if the employee is 50% or more at fault, then there's not going to be a recovery. So when the workers' compensation carrier files its lien, which they always do, and they file an intervening petition, which they always do in any lawsuit, the first thing that's going to come back when we're trying to settle it is, gee, guys, do you think maybe that there might be some comparative fault on the part of plaintiff? And if the workers' comp carrier, the employer, or the TPA holds his hand out and says, well, we're not going to settle a case unless you pay us 100% of what we're owed, then the next question that comes back to them is, and how much are you willing to roll the dice to see whether or not that jury's going to come back and find against your defendant? Because right now we're offering you a piece of the pie to settle it, but if you want to roll the dice and they find out that the plaintiff is 50% or more, you're not going to get a dime. Now, there is no employer discussion that's going on right there. This is insurance. This is called a matter of risk. And this is the same risk that we're asking that you to assume for this legislation that you would assume for the situation in which you just simply are saying, well, are we going to be able to recover it all from the plaintiff? So I think we can address that. I don't think this will make any difference at all in the way cases are handled. I think it just simply adds another component to it if you get into a third-party situation. And let's face it, frequently the employer has nothing to do with anything. I mean, there's simply there's no exposure on the part of the employer, so you don't even have to worry about it. It's just a matter of what has the employee done and what has the third-party defendant done. So I don't like to buy trouble, but I do like to look ahead for trouble, and I just don't see the issue of this being a burden on the employer as coming to pass, because you've already got to deal with the same burden in terms of the comparative fault. The rates. We've talked about the fact that, we haven't, but I understand the committee did, whether or not there would be an adverse impact on rates for because of however many accidents that the employer has at the end of the year. And I get that. But I also get the fact that if I am a third-party defendant and I'm looking at a CGL policy and I've just paid out $20 million on a case that maybe I shouldn't have paid out but about $1 million on, I can assure you that the rates for the CGL policy is going to go up either worse or they'll get canceled. So I suggest to you that we don't just look at from a workers' compensation standpoint, but we also look at the third-party defendant and look at the position they're in, because now they're being forced to pay a judgment that they shouldn't have to pay, and then on top of that, they're dead. And let me tell you why this came up. And if it's time for me to leave, let me go. But I have been involved in 3 cases in which there were catastrophic injuries. And when I say catastrophic, I mean where someone is a quadriplegic or a paraplegic, and maybe they've got children and families, and this was before the caps, but maybe you were looking at multi-millions of dollars in verdict against them. And I've also looked at the small contractor that I'm representing, who maybe had $5 million in insurance, and maybe he's about 5% at fault, and maybe the employer is about 95% at fault. And maybe he could have easily have handled the 5% if he went to trial, but if he's 100%, he's bankrupt because he's going to be paying for the entire thing. And I've had several cases that I've had to settle within policy limits, even after I've hired a mock jury with 21 members of a jury on a couple of occasions to go through and listen and allocate fault. And I've had juries come back with 95% fault as to the employer. And understand that when I'm trying these cases to these mock juries, I'm actually trying to make it as bad on me as I can. I'm not looking to smooth it over because I want to know what my risk is. And to sit there and realize that you've got an employer that may be 90, 80, whatever, it doesn't make any difference, that much at fault. And yet, we're not going to be able to hit 100%. So now I've got to tell my client, you're going to have to pay the entire thing, regardless of the fault of the employer. And I've had to do that quite a number of times in the last 5 years, which is one of the reasons why I went and said this has got to be fixed. This is just simply patently unfair. This state has always, I believe in Tennessee, and Tennessee has always held people accountable. And what this bill does is it makes people accountable, and it fixes it.
Questions of Mr. Summers about his remarks? Mr. Fox, you recognized.
I'm trying to get my head around this. Would the fault of the employer reduce the recovery to the injured employee? It would, wouldn't it?
Reduce the recovery?
Yes.
As to the third party?
As to the third party.
Yes, sir. And the reason would be that he sues B. B comes back and says, okay, you're employee, you're 10% at fault. Employer, say you're 30% at fault, and I'm 70% at fault. So he's only going to get 70% against me because I'm going to get a credit for the 10% against the employee and the 20% or 30% against the employer. So yes, it will reduce it.
Is the fault of the employee not imputed to the employer?
No. No, you would have individual. I mean, your fault is your fault. So in the example I just gave you,
every other scenario of tort liability, the trucking company, the tractor and trailer driver's fault is imputed to the owner of the trucking company. True?
yes, unless there is but you can also have independent fault on the part of the employer. And I think what I'm thinking in terms right now is I'm thinking in terms of independent fault of the employer that may exist separate and apart from whatever the employee did.
I understand, but the employee's fault is going to get imputed to the employer, and the employer's fault is going to get stacked on top of that. And if it's over 50%, then the injured person would not recover. True?
No, I don't think that was the way the bill was intended to be written. No, I don't see that.
Is that the consequence of it?
I don't believe so, because I think the way the statute's written is it speaks to the allocation of fault as to the employer, and we're not talking in terms of an agency relationship. And I understand where you're coming from, but I don't believe that I think that when we go down on that form, on that jury form, we're going to be looking at the comparative fault of the employee. You're going to be looking at the fault of the employer, if any, and the fault of the third-party defendant.
But the jury's going to be charged by the judge that they can consider the fault of the employee imputed to the employer. True? I'm trying to get my head around this too. I mean, I'd like some time to
Typically,
I'd like some time to think about this in a little more detail than what we're confronted with here today.
Typically, Mr. Fox, that imputation is where you're actually suing the plaintiff. I mean, the trucking company and its employee. Here, there's an allocation of fault that is not the same thing as suing the employer. And you're not suing the employee either. This is merely an allocation of fault.
But in your answer, you're going to allege fault.
I'm going to, yes.
And in the trucking incident, if the trucker's at fault in causing the accident or some portion of fault, you're going to allege fault against him and ask that it be imputed to the employer, and you're going to allege fault against the trucking company for the purposes of reducing your liability. Am I grabbing that right?
If there is no, you're saying I'm going to impute. If you think it's 50% or more, then it's 50% or more, and I win. Are you saying that we're going to I guess what I'm trying to get to is that when you're talking about agency, I see that separately as the independent fault of the two parties. Because if it's an agency argument that you're making, which it is, that whatever the plaintiff did is imputed to the employer, then what difference does it make? Because if it's 20 cents, 30%, whatever, then we're going to just, that will be the allocation until we get up to 50%, and then the defendant wins. But I think in the situation we're talking about, we're not getting into that kind of agency. I mean, we're just simply talking about the independent negligence of the employer.
This is better than a law school exam question, isn't it? It's thought-provoking.
It is.
And I'd like, I'm not sure I'm prepared to really sort that out today. I had not given it thought before today. I'll be candid with you because it just hadn't sunk into me until you started explaining it, what this bill did. And maybe Mr. Ramos or Mr. Denton can enlighten me a little further about what the final impact will be, because under our comparative fault scheme, I see the injured employee who may have a third-party claim against another entity not recovering simply because the employer's fault is going to get them over 50%. But I want to think about that.
Okay, Mr. Ramos is recognized.
Thank you. I had the same concern initially, but I think I understand what you're saying now. So, simple hypothetical. The employee brings a lawsuit, automobile accident, against a third party. The employee is determined to be 10%. And by the way, I forgot to mention the third party brings in the employer as a defendant, third party defendant. So the employee is determined to only be 10% at fault. But hypothetically, the employer is determined to be 41% at fault, bringing it to a total of 51% between the employee and the employer. You are saying, in response to Mr. Fox's questions, that the employee won't be burdened with that 41% of fault that is assessed to the employer. That fault is independent.
Yes.
And the fact that the two together add up to 51% doesn't totally defeat the employee's personal injury claim.
That's correct.
Correct? Okay. That I just wanted to make sure I was understanding what you were saying. Thanks.
Because in the example you just gave, we're at 51%. So from the standpoint of the defendant is only going to pay 49% of that's all, because that's his fault. And all we're doing right now is we're saying we've got 49% fault to Mr. Third Party Defendant, and that's really all I'm worried about is the third party defendant and to what extent he has to pay or she has to pay in terms of fault. And this is what this says. So. Now, if the plaintiff himself is 50% or greater without going through, taking it through the agency relationship, then, you win anyway.
Other questions of Mr. Summers and his remarks? All right, seeing none. Thank you, Mr. Summers, for your remarks.
Thank you, Mr. Chair.
Okay. Dave Bramell, do you want to speak to this? Please identify yourself for the record and also your affiliation.
Thank you, Mr. Chairman. David Bromell on behalf of American Insurance Association. On behalf of the employers and the people who insure them, we have a very different view of what this bill does, because the employer has to pay the injured employee regardless of fault, 100%. Comparative fault, contributory, it doesn't come in to the equation. And the injured employee has the right to go after the tortfeasor, but the courts have been consistent in saying our subrogation interest, our lien, should not be diminished because it's a no-fault situation, and that this bill will do away with that. And another inequity that you'll find here, the courts have said that even though the employer may have the obligation to pay a huge amount in future medical, because the workers' comp law gives the injured employee, and rightfully so, future medical, we're not able to take credit for that. So our position is going to be damaged by this, and I think the courts have recognized it's not fair And I would urge you to vote against this bill to maintain equity. Any
Questions of Mr. Bromell? All right, thank you, sir.
Thank you.
All right, further remarks from anyone on the panel or anyone in the audience about this bill? All right, we're in discussion on the bill at this point. House Bill 2194, Senate Bill 2580 by Representative Coley and Leader Norris. Chair will entertain either the discussion or a motion. Mr. Pitts is recognized.
Mr. Chairman, I'm sort of reluctant to do this, but I think the gentleman from Memphis has brought up some interesting points. But again, from a historical perspective, a bill similar to this was up either 2 or 3 years ago. And frankly, as I remember, the council recommended against it. There has been no discussion on this subject in the hallowed halls of the legislature since that time. I'm of the opinion, and I could be totally wrong, that if this bill is pressed forward today, it will not get a favorable recommendation. My suspicion is some of my colleagues on the other side down here are sort of thinking that it probably would be in the best interest for some continued education and some of us to revisit it with our folks. But I'm of the opinion that if it goes forward today, it'll get a negative recommendation. I'm sort of trying to sense where folks are. If everybody's going to dump me in the ditch, I'm not one to sit around and not make a decision. I would move that this bill at the present time go out with a negative recommendation.
All right, we have a motion by Mr. Pitts to move the bill out with a negative recommendation against passage. Is there a second for that motion? All right, we have a second. Mr. Schaefer seconds. All right, any discussion on the motion as it's been made? Mr. Fox is recognized.
I would suggest to the sponsors that they bring it to us again and let us give it some more thought and try to get our minds around what the right thing to do would be. I'm struggling with it today.
Okay, is there further discussion on the motion that's on the floor at this point? Or says, you know, the council cannot kill a bill. It can simply delay it slightly to allow further consideration if that's what members want to do. Of course, we're deep into the legislative session here now, and the sponsors of the bill have a right to have the heard bill in regular committee, so we can't deal with that very much over an extended period of time. But all right, is it the will of the body we have a vote on the motion? It seems so. Would you call the roll, Ms. Schroeder?
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Gary Selvey. Paul Schaefer. It's unanimous.
Motion having been unanimously adopted by the voting members, the bill goes out with a negative recommendation. See, the next item on our calendar is House Bill 2404 and Senate Bill 2482 by Representative Travis and Senator Massey. It's my understanding that this bill has been withdrawn. So is there anyone here that has information to the contrary? If not, we'll withdraw it off our calendar. All right, seeing none, then that brings us to the close of our calendar today. We have one other thing, and that is to arrange for a meeting to consider the NCCI law-only filing. The suggestion is to have that meeting on Monday, March 21st at 1:30 p.m. Is that acceptable to members? March 21 at 1:30 p.m. Unless there are further bills referred to the council, this constitutes what we've heard today and other actions constitutes all of the bills except for one caption bill have been referred to the council to date. And while we're in this pause here for a minute, I want to be sure and acknowledge the presence of Chairman Jimmy Eldridge here from Jackson, Madison County. We're so glad you're with us today, Chairman. Appreciate your participation in our meeting. All right, comments on March 21 at 1:30 p.m. Looks like it's good, right? Okay. We'll have the next meeting on that date unless we otherwise determine. So is there any further business to come before the Tennessee Advisory Council on Workers' Compensation? Seeing none, without objection, the chair will declare the meeting adjourned. Thank you for your participation.